Welcome to Week 12 of Evidence. This week we cover the topic of scientific and demonstrative evidence. We'll cover the cases from your casebook on pages 852 to 905. The first case we covered was General Electric v. Joyner. This is a Supreme Court case from 1997. As background, the plaintiff, an electrician, claimed that exposure to transformer fluid containing PCBs caused him to develop lung cancer. The plaintiff then brought suit against the defendant, the manufacturer of the transformers. The trial court granted summary judgment for the defendants, finding that the plaintiff's experts did not meet the Daubert standard for expert testimony, and therefore the plaintiff had not met his burden to prove the elements of his case. The case was appealed, and the appeals court reversed and held the trial court to a stringent standard of review instead of an abuse of discretion standard. At issue was, should the expert testimony have been admissible, and was the appeal standard of review appropriate? The Supreme Court disagreed with the appellate court's ruling on the proper standard of review, and it upheld the trial court's decision on the admissibility of the expert testimony. The Supreme Court held that the proper standard of review was an abuse of discretion standard. The reasoning behind this is a trial judge gets to see the whole picture of a case. They're making decisions based on the cumulative evidence at trial, dealing with issues like time consumption and confusion for the jury. And that is something that the upper courts do not get to see. The next case is Kumho Tire Company versus Carmichael. This is another Supreme Court case from 1999. As background, the defendant's expert witness at trial, an engineer and tire expert, testified that the cause of a blowout was a defect in the tire, not abuse or overinflation or overdeflation. The expert witness theorized that the blowout was caused by a separation of the thread of the tire from the carcass. He also said that tire misuse or overdeflation could lead to separation only if at least 2 of 4 signs of physical deterioration were present. When the expert inspected the tire and he found that it was not abused, even though there were some signs of abuse. At issue was, did the trial court abuse its discretion in excluding this expert testimony and granting summary judgment? The Supreme Court held that no. The trial judge did not abuse its discretion in deciding not to admit this expert testimony. The criteria for validating a scientific theory under Daubert are flexible, and a trial judge has discretion in deciding how to assess the validity of evidence in a particular case. The next case is Ellis v. State. This is a Court of Criminal Appeals of Oklahoma case from 1982. As background, the defendant appealed a conviction of larceny of a domestic animal. The defendant argued that there was insufficient evidence to sustain a verdict against him. At the original trial, the complaining witness said that they had lost a newborn calf. The plaintiff introduced evidence that a calf found in the neighbor's barn where the defendant was the missing calf, and they did this by introducing testimony from a lifelong cattleman as their expert witness, who stated that the mother cow had allowed the calf to suckle her, and that is how he determined that the calf was their mother. At issue was there enough evidence against the defendant at trial to support a verdict? This court held that the trial court did not err, that the circumstantial evidence presented at trial was enough to establish at least a prima facie case, and that the trial court properly denied the defendant's motion for a directed verdict. The next case is Almasiga v. Center for Investigative Reporting. This is a United States District Court case from the Southern District of New York from 2016. As background, the plaintiff claimed that the defendant had violated an agreement to conceal her identity in a video, which included a member of a drug cartel. The defendant contended that the plaintiff had signed a release allowing for her identity to be exposed. The plaintiff alleged that the release was forged. The trial court dismissed the case and actually held that the plaintiff and her attorney had perpetrated fraud by even making the forgery allegations. The plaintiff presented an expert witness who contended that the signature was forged, but during trial also said she did not know whether the comparison signatures she was basing her decision on were actually the plaintiff's. So during trial, the court had the plaintiff write out her signature 10 times in court. The expert then testified that the comparison signatures were the plaintiff's, and she repeated her opinion that the signature on the release was forgery. At issue was, does handwriting analysis qualify as scientific expert testimony under the Daubert standard? The court analyzed the Daubert factors and held that ultimately handwriting analysis was not subject to adequate testing or peer review, that the error rates were too high, and that the field lacked controls and standards. The court held that this expert's testimony should not be admissible at trial. The next case is State v. Porter. This is a Supreme Court of Connecticut case from 1997. And in your casebook, this is just an excerpt of the opinion. So as background, Connecticut has a per se rule excluding polygraph evidence. This excerpt of the opinion reviews polygraph studies to determine the scientific status of polygraph exams. At issue is whether there should be a per se rule excluding polygraph tests. As a holding, this court adopted the Daubert standard and reaffirmed Connecticut's per se rule against the use of polygraph evidence. The court held that the probative value of a polygraph test is not significantly greater than that of a coin toss, especially for a failed test. A coin toss arguably has no probative value, so do you agree with the court here that a polygraph test has little to no probative value? Next case is State v. Alexander. This is a Court of Appeals case of Alaska from 2015. The defendant was accused of sexually abusing a minor. The defendant had a well-known polygraph expert administer a polygraph test. The expert concluded that the defendant was telling the truth in his denial. At the same time, a defendant in another similar separate case had also hired this expert and had the same result. The expert said he was 90% sure that both defendants were telling the truth. The judges from the two cases held a consolidated hearing to determine whether the polygraph tests should be admissible in both trials. In the consolidated hearing, the judges set two conditions on admissibility. One, that each defendant would have to submit to another polygraph test by a state-chosen expert, and two, that each defendant would be required to testify at trial and be subject to cross-exam. The other defendant ended up failing their state-administered exam and then pled guilty. The defendant here, Alexander, appealed the consolidated hearing ruling. At issue is, what is the appropriate standard of review for admissibility of polygraph tests? This court upheld the two conditions the trial court placed on admissibility, though it also suggested that, in light of the other ruling on the defendant's case, that the trial judge in Alexander's case should reconsider its ruling. Next case is Commonwealth v. Walker. This is a Supreme Court case of Pennsylvania in 2015. As background, defendant was accused of armed robberies. Multiple victims had identified the defendant from a photo presented by the police and also identified him at trial. The defendant wanted to present expert testimony on eyewitness testimony, so analyzing how reliable it can be when considering different factors, like whether a weapon was present. But ultimately, the court rejected this expert evidence. The defendant was acquitted of one robbery, but convicted on the others. The appellate court affirmed. At issue is, when should expert testimony on the reliability of eyewitness testimony be admitted? While Pennsylvania had previously excluded this type of evidence, this court followed the more modern trend and held that the evidence should be allowed at the discretion of the trial court. Our last case is People v. Collins. This is a Supreme Court of California case from 1968. The defendants were accused of robbery. A witness said she saw a blonde woman with a ponytail fleeing the scene and getting into a yellow car driven by a bearded black man. The defendants, a married couple, closely fit this description, though it was disputed that Mr. Collins had a beard on the day of the crime. The plaintiff offered expert testimony that the probability of a couple chosen at random fitting this description was 1 in 12 million. The defendants were ultimately convicted. At issue is whether the expert's testimony was based on proper scientific techniques. The court held that the expert testimony and the prosecutor's presentation of the evidence lacked an evidentiary foundation and had inadequate proof of statistical independence. Another easier example of this same type of problem can be found on page 906 of your casebook in the section titled The Red-Haired Soldier. Again, this gives another example of a prosecutor and an expert's flawed calculation with this type of probability.